Good afternoon, and thank you for joining us today for part 2 of the Employee Classification webinar series. And for anyone who missed last week, we'll be sending out a link later today, along with a recording of this program and the slides. I'm Amy Weeman, the head of marketing here at MP. And for those of you joining us on a webinar for the first time, MP is a full-service human capital management company, offering a complete suite of products and services to support employers through the entire employee life cycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. You have two phenomenal presenters today from the HR team here at MP, Sheri Heller and Amanda Leonardi. Sheri is a SHRM and PHR certified HR partner here at MP. She has over 20 years of experience in employee relations, training and development, strategic planning, and policy development. Sheri earned a Master of Education in Instructional Design from UMass. She spent many years in retail management prior to getting into HR, which provides her with a unique business focus to human resources. Amanda Leonardi is an HR partner here at MP as well. She currently provides HR support to businesses of all sizes in a variety of industries. She previously managed HR for a human services nonprofit organization. Amanda received her BA from Duquesne University in Pittsburgh and received her SHRM certification in 2019. Just a few housekeeping notes. If you'd like to submit a question during the program, please use the Q&A feature at the bottom, and we'll address questions at the end of the program. And again, a recording of the webinar will be sent out later today, following the presentation along with the slides. And with that, I'm going to hand the mic off to Sheri.
Thank you, Amy, and good afternoon, everybody. As always, we start with our legal disclaimer. We are going to be talking a lot about employment law today, but this training is intended for informational and educational purposes only. While we hope you learn a lot today, we're not attorneys and we don't want anything to be construed as legal advice. With that, let's talk about our presentation topics today. So if you joined us last week for part 1 of our Misclassifying Workers series, we were focusing on exempt and non-exempt classifications under the Fair Labor Standards Act. Today, we're going to shift our focus to determining whether a worker is an employee, a W-2 employee, or a 1099 independent contractor. So we'll talk a little bit about the difference between the two of those. Then we'll look at how independent contractors are defined by the Department of Labor, also by the IRS, and then we'll also talk about state law considerations. Then we'll talk a little bit about misclassification audit triggers, misclassification myths, and tips for using contractors. So with that, let's talk about the difference between a W-2 and 1099 worker. So how you classify a worker is subject to review by various government agencies, including the IRS, Department of Labor, state workers' compensation, state unemployment insurance, state tax departments, and state labor departments. Each of those agencies work independently of each other, and their definition of employee can differ depending on the agency and the applicable laws. So we're going to take a look at how the Department of Labor, IRS, and various states look at independent contractors. So when we're trying to decide whether somebody should be classified as an independent contractor or an employee, the impact of that in that classification really affects payroll and wages, taxes, and who's responsible for paying them, eligibility for workers' comp and unemployment insurance, eligibility for company benefits, and protection under federal and state laws. Bottom line is, both at the state level and at the federal level, misclassifying somebody as an independent contractor from both the state and federal perspective is that you are denying people protection under the various federal and state laws. You're denying them benefits and the opportunity to collect unemployment, as well as affecting payroll taxes and wages. So with that, we're going to talk a little bit about, under the Department of Labor, this is the federal level, how they define independent contractors. You may have heard a lot of media coverage throughout 2020 and 2021 regarding independent contractor rules. So during the Trump administration, the U.S. Department of Labor proposed an update to the rules governing the classification of independent contractors. However, shortly after the Biden administration took office, the Department of Labor issued a notice to withdraw the proposed rule. So as a result, on May 6, 2021, the proposed independent contractor rule was officially withdrawn, and the Department of Labor will continue to use the more traditional, quote unquote, economic. Got it?
Good as new.
Oh, awesome. Awesome. Boy, this is a day of technical difficulties. All right. So we're going to look at the kind of questions you should be asking yourself as an employer for each of these factors. So in relation to the extent services rendered are an integral part of the business, questions you want to ask are, does the worker perform the primary type of service that your business provides for customers or clients, or a regular job that is part of your business's overall process or production? So this factor relates not to the percentage of work done by the worker, but to the nature of the work. In other words, is the work done an essential part of your business? Work that is a necessary part of a regular trade or business is normally done by employees. So for example, a baker is a key element in a bakery business. It's likely that the bakery would have the right to control or direct the work of the baker because their success determines the success of the bakery. This would indicate an employer-employee relationship. On the other hand, a plumber that you engage to fix the pipes in the bathroom of a store is performing a service on a one-time or occasional basis that's not an essential part of your business. A certified public accountant engaged in preparing tax returns and financial statements for the business could also be an example of an independent contractor. When a worker furnishes tools and materials such as a plumber would, especially when a substantial sum is involved, there is an indication of independence. Another question you would ask is, does the worker regularly supervise any of your business employees? A worker who regularly supervises any of your employees is an employee acting in the capacity of a manager or supervisor. An independent contractor should only be supervising workers that they have hired and pay. An independent contractor, such as an accountant, who in the course of their work requests information or other action from an employee of your business, is not engaged in a regular supervision of that employee. And you also would want to ask, does the business have employees with substantially similar job functions, duties, and responsibilities? So if the work being done is basically the same as work that is normally done by your employees, it indicates that the worker is an employee. This applies even if the work is being done on a one-time basis. So for instance, to handle an extra workload or replace an employee who's on vacation, a worker is hired to fill in on a temporary basis. This worker is a temporary employee, not an independent contractor. All right, so the next factor that they look at is the permanency of the relationship. So you should be asking, did your business engage the worker with the expectation that the relationship will continue indefinitely rather than a specific project or period? So if your business hires a worker with the expectation that the relationship will continue indefinitely rather than a specific project or period, this is generally considered evidence that the intent was to create an employer-employee relationship. The employee relationship between an independent contractor and their client ends when the job is finished. So if the worker continues to be paid during downtimes, this also points to a more permanent employer-employee relationship. If the relationship consists of continuing or recurring work, the relationship is considered permanent, even if the services are rendered on a part-time basis, are seasonal in nature, or if the person actually works for only a short time. Another question you should ask is, can the worker be discharged at any time without risking a lawsuit? So if a business has the right to discharge a worker at will and without liability, that worker is likely an employee. The business exercises control through the ever-present threat of dismissal, which causes the worker to obey instructions. So the worker is dependent on the business that they serve. An independent contractor, on the other hand, cannot be discharged without liability as long as they produce a result that measures up to the contract specifications. Next factor is the amount of the alleged contractor's investment. So again, a question that you would want to ask is the investment made by the worker in order to perform the services minor or relatively small compared to the investment of your business? So this factor takes into account whether the worker must make a substantial monetary investment in order to perform the services. The investment made by the worker are compared to the investment made by the business. So if the amount invested by the worker is minor or relatively small compared to the investment of the business, this factor weighs towards an employment relationship. The converse is also true. So there is no set dollar or percentage limit that qualifies as a substantial investment. It's really determined on a case-by-case basis. Another question to ask is the worker reimbursed for any purchases, travel, or other expenses incurred in connection with the work? So if your business reimburses expenses incurred in connection with the worker is generally an employee. An independent contractor, on the other hand, is usually paid on a job basis and is responsible for all incidental expenses incurred in connection with the work. Another question to ask is, does your business pay the worker's assistants or other workers? A worker whose assistant is, is paid by your business is likely an employee. A worker who pays their assistants or other workers is likely an independent contractor. All right, next factor is the nature and degree of control by the principal. So again, question to ask, is the worker required to comply with your instructions about when, where, and how their services are to be performed? So if your business has the right to control or direct not only what is to be done, but also when, where, and how it is to be done, then the workers are most likely employees. If your business can direct or control only the result of the work done and not the means and methods of accomplishing the result, then the workers are probably independent contractors. So types of instructions could include things like where and when the work is done, what tools or equipment to use, what workers to hire or assist with the work, where to purchase supplies and services, what work must be performed by a specified individual, or what order or sequence to follow when performing the work. The more detailed the instructions, the more control the business exercises over the worker. The more detailed instructions indicate that the worker is an employee. Less detailed instructions reflect less control, indicating that the worker is more than likely an independent contractor. Does your business generally exercise more than minimal supervision of the worker? Minimal supervision is a factor weighing towards an independent contractor status. Generally, a business manager assigns, reviews, and significantly supervises only the work of the employees. The requirement of regular oral or written reports indicates control, and therefore employee status, since the worker must account for their actions. An independent contractor is usually not required to file reports that constitute a review of their work. And thirdly, does your business have the right to hire, fire, or supervise assistants of the worker? If your business hires, fires, or supervises assistants of the worker, that worker is probably an employee, while an independent contractor would hire, fire, or supervise their own employees or their own assistants under a contract that requires them to provide materials and labor and is responsible for the results of the worker's performance. And then the alleged contractor's opportunity for profit and loss is another factor that's looked at. Is the worker unable to make business decisions that would result in the worker earning a profit or incurring a financial loss? So the ability to realize a profit or incur a loss strongly indicates that a worker is an independent contractor. When workers are insulated from loss or restricted in the amount of profit they can gain, they are usually employees. An individual is normally an independent contractor when they are free to make business decisions which impact their ability to profit or suffer a loss. This involves real economic risk, not just the risk of not getting paid. So whether a profit is realized or a loss suffered generally depends on management decisions. That is, the one responsible for the profit or loss can use their own ingenuity, initiative, and judgment in conducting business, Independent contractors typically can invest significant amounts of time or capital in their work without guarantee of success. And then the amount of initiative, judgment, or foresight in open market competition with others. So the questions you would ask are, does the worker perform only routine tasks requiring little training? So a low-level technical skill is a strong evidence of an employment relationship. Since the the skill level declines, there's less room to exercise the discretion necessary for independence. The courts have held that workers who are considered unskilled or semi-skilled are the type of workers the law is meant to protect and are generally employees. Another question to ask is, did your business spend significant amounts of time and money providing training for the workers? So businesses hire independent contractors with the understanding that the workers provided will possess the necessary skills and initiative to satisfactorily perform their job, while businesses generally only pay for the development of occupational skills as an investment in their own employees. So some other factors that the courts will look at in determining employee status are things like, did you give them a job description? Do you keep a personnel file on the individual? Are you giving them performance evaluations? Are you having them sign off on your handbook? Are they receiving any benefits? Maybe company equipment. Are you providing the computer? Are you providing an email address? Things like that. Are they listed in your employee directory? And did you give them business cards? Those factors can indicate an employee status. All right, and with that, I'm going to turn it over to Amanda to talk about independent contractors under the IRS.
All right, thank you, Sheri. So as Sheri just mentioned, we're going to look at how the IRS assesses whether a worker is an employee or an independent contractor. And if you're like me, you get the heebie-jeebies when you hear or have to talk about the IRS, but we're going to power through it together as a team here. So the IRS uses what's commonly referred to as the 20 common law factors to assess whether a worker is an employee or an independent contractor for employment tax purposes. And the general rule of thumb and kind of the elevator pitch according to the IRS is that an individual is an independent contractor if the payer has the right to control or direct only the result of the work and not what will be done and how it will be done. On the flip side here, the IRS considers an employee to be anyone who performs services for you if you can control what will be done and how it will be done. So what matters is that you have the right to control the details of how the services are performed. So again, you have a contractor relationship in the eyes of the IRS if you only have the right to control or direct the ultimate end result of the work and not actually what will be done and how it will be done. And you have an employee relationship if you can control what will be done and how it will be done. All right, so as I mentioned earlier, the IRS uses 20 common law factors to examine whether a worker is an employee or a contractor. And although these are still valid today, the IRS has actually grouped the more relevant ones into 3 main categories of evidence, which so nice of them to simplify things. So when you're using the common law test to make this determination, all information that provides evidence of the degree of control and the degree of independence must really be considered. And again, this falls into 3 main categories. So we have the behavioral control, financial control, and then the type of relationship of the parties. So first, we're going to tackle the behavioral control. And this really covers the facts that show whether the business has a right to direct or control how the work is being done through instructions, trainings, or other means. And an employee is generally subject to, business instructions about where, when, and how to work. So first, you want to think about whether the worker is required to comply with instructions on those items. And this is really an important factor. So if your business does have the right to control or direct not only what's to be done, but also when, where, and how it's being done, then the worker is most likely an employee. If your business can direct or control only the result of the work and not the means and methods of accomplishing that result, then the workers are probably independent contractors. So some types of instructions when they define the word instructions include things like when and where to do the work, what tools or equipment to use, what workers to hire or assist with the work, where to purchase those supplies and services, what work must be performed by a specified individual. So those items really have a lot of overlap with the Department of Labor standards that Sheri mentioned earlier. And keep in mind, independent contractors are free to do jobs in their own way using specific, methods that they choose. So a business engages an independent contractor ultimately for the job's end result. And when a worker is required to follow company procedures, company manuals, or is given specific instructions on how to perform the work, then you really have an employee relationship there. And then the next thing you want to take a look at when it comes to behavioral control is any training that the business is giving the worker. So, providing detailed methods and procedures to be used in performing a task. That's what they mean when they say training. And if the business provides the worker with, training on how to do the job, this indicates that, the business wants the job done in a particular way. So this is strong evidence that the worker is an employee. And training can really be as informal as requiring the worker to attend meetings or work alongside someone with more experience, and periodic or ongoing training about procedures or certain methods is even stronger evidence of an employer-employee relationship. So again, a contractor uses their own methods and in turn does not need to receive training from the purchaser of those services. All right, the next factor here is financial control, and this covers the facts that show whether the business has a right to direct or control the financial and business aspects of the worker's job. So these controlling factors include the extent to which the worker has unreimbursed business expenses. So if the employer pays a worker business and travel expenses, the worker is generally an employee. An employer who's able to control expenses also generally retains the right to regulate and direct the worker's business activities. On the other hand, a worker who's paid, on a job basis and who has to take care of all the incidental expenses on their own is generally an independent contractor. And really, since this person is accountable to no one else for those expenses, the person is free to work according to their own methods and means. So that's more of a contractor relationship. Then we have the extent of the worker's investment. And an independent contractor often has pretty significant investment in the either facilities or tools that they use in performing the services for other people or other businesses. And that being said, a significant investment isn't really necessary for independent contractor status, but is oftentimes considered evidence. Then we have the extent to which the worker makes their services available to the relevant market. So an independent contractor is generally free to seek out business opportunities on their own. They often, advertise, maintain, a business location, are available to work in relevant markets. And when individuals hold themselves, out to the general public as available to perform services similar to those performed for an employer, it's evidence that the individuals are operating separately, a separately established business and would normally be an independent contractor. However, if a worker performs services for only one person, one business, does not advertise their services to the general public and performs services on kind of a continuing basis, it is an indication of an employee relationship. So then we have how the business pays for the worker. And an employee is generally guaranteed a regular wage, amount for hourly, weekly, monthly pay, a certain period of time. And this usually indicates that a worker is an employee even when the wage or salary is supplemented by a commission. On the other hand, an independent contractor is often paid a flat fee or an on-time and materials basis for a job. But with that being said, it can be common in some professions, such as law, to pay independent contractors hourly, but that's something to keep in mind. And then last but not least, the extent to which the worker can realize a profit or loss. So an individual is typically an independent contractor when they're free to make business decisions that really impact their ability to profit or to suffer a loss. And this really involves, true economic risk, not just the risk of not getting paid. So those are the financial factors that the IRS looks for. And then last but not least, we have the third factor, which is the type of relationship. And this covers facts that relate to how the worker and the business owner perceive their relationship. So, those facts that show the type of relationship can include things like written contracts describing the relationship of the parties and what relationship they intend to create. whether or not the business provides the worker with employee type benefits like insurance or a pension plan, a vacation pay, sick pay, those types of things. The permanency of the relationship. So if you engage a worker with the expectation that the relationship is going to continue indefinitely, rather than for more of a specified period of time or a specified project, this is generally considered evidence that your intent was to create an employer-employee relationship. And then the extent to which services performed by a worker are a key aspect of the regular business of a company. So if a worker, provides services that are a key aspect of your regular business activity, it's more likely that you'll have the right to direct and control their activities. So, for example, if a law firm hires an attorney, it's likely that it will present, that attorney's work as its own and would have the right to control or direct that work. And this would indicate an employer-employee relationship. All right, so we wanted to share some practical examples that illustrate the application of the IRS test factors. And for the purposes of time today and due to some of the technical difficulties, I'll just go through this first example, but there are 3 of them that you can review when we send out a copy of the slide deck afterwards. But this first example on your screen here, we have an attorney or an accountant. They have their own office. They advertise in the yellow pages of the phone book under, throwing it back there, under attorneys or accountants. They bill clients by the hour. They're engaged by, a job or paid an annual retainer, and they are able to hire a substitute to do the work. So in this example, this would be an example of an independent contractor. However, on the flip side, if the attorney or accountant, they would be considered an employee if they're employed by a firm to handle their legal affairs or financial records, work in an office at the firm's place of business, attend meetings as needed, and the firm bills the clients and pays the attorney or accountant on a regular basis. So you can see the different factors that we just covered coming into play here. In the contractor example, they're handling and advertising their own business, investing in their own space, taking care of the billing themselves. They're paid on a flat fee basis. And have the ability to hire help for themselves to step in and assist with the work, versus the employee example, where all of those things are handled and controlled directly by the firm. So Sheri, if you could skip through, yes, to the next slide, perfect. So not to use scare tactics here, but there are some IRS penalties for misclassification that you certainly want to avoid at all costs. If the IRS determines that an individual has been misclassified, it may levy penalties against the employer, including but not limited to a $50 fine for each Form W-2 the employer failed to file on each misclassified employee, a penalty of up to 3% of the wages, plus up to 40% of the FICA taxes that were not withheld from the employee, and up to 100% of the matching FICA taxes the employer should have paid. So they want their money, honey. And if the IRS, determines that an employer misclassified its employees willfully, knowing that they were misclassified, the penalties are even greater. And these penalties can be costly and in some cases devastating for an employer. So you really want to do your due diligence and make sure your employees are properly classified. All right, throwing it back to you, Sheri.
All right, so we've talked about IRS, we've talked about Department of Labor, but state employment and workers' compensation laws are often more stringent than the federal DOL or IRS. Excuse me. So most state laws contain strict tests to determine whether there's a sufficient absence of control by an employer that the worker is not an employee but an independent contractor. Many of the states provide criteria that's commonly known as the ABC test, under which service for remuneration is considered employment and the worker is an employee unless each of these 3 factors are met. So first off is the worker is free from direction or control in the performance of the work under the contract of service and in fact. So again, just like with the IRS or DOL, is that you as the business only control what is the final product, what is to be done, not how and when and where it's done. Second, excuse me, or B is the service is performed either outside the usual course of the business for which it is performed. So if you are a software company and you are bringing on an independent contractor who's going to be doing software development that is not outside of your usual course of business, it is part of your usual course of business, so you would not meet that test. Is the individual customarily engaged in an independent trade, occupation, profession, or business? So again, you need to keep in mind that the worker has to meet all three of those factors to be considered an independent contractor. Excuse me. All right, and I'm going to bounce it right back to you, Amanda, to talk about these triggers.
All right, so it's important to know that claims of employee misclassification are on the rise, due in large part to stepped up audit and enforcement efforts by both the federal government and states targeting employees that improperly employers that improperly treat employees as independent contractors. And the focus on how employers classify their workers is honestly likely to increase as the IRS and the DOL carry out their plans to audit thousands of companies, which does include small businesses, for possible misclassifications. In addition, state officials are really searching for ways to boost revenue, especially after the last 2 years, and have also intensified investigations of state wage and hour laws. And oftentimes, we think, there's no way they'd be knocking on my door. However, the reality of the situation is that these things can be easily triggered based upon the actions of your workers. So we wanted to take a minute to go over some common worker misclassification audit triggers, so you're aware of how misclassifications are oftentimes brought to light. So these things can be triggered if the 1099 independent contractor files a claim for unemployment benefits. This creates suspicion because independent contractors are not eligible for unemployment. Another trigger is if the independent contractor files a workers' compensation or a disability claim against the employer. If someone is truly an independent contractor, they should carry workers' compensation themselves and disability insurance themselves because they're not eligible through an employer. Also, if a worker receives a Form W-2 and a 1099 form from the same employer in the same year, that's oftentimes an indicator that they converted from a 1099 independent contractor to a direct hire of the company. And oftentimes, if they perform the same work as the 1099 contractor as a W-2 employee, the IRS might wonder why they were not originally classified as an employee. It also can be triggered if the worker feels that they're being improperly treated as a contractor and files an unpaid, minimum wage or overtime complaint with the DOL. Also a red flag if an independent contractor, has been working for a particular company for a long period of time. And then last but not least, if you have a high 1099 volume, that might be an indicator of misclassification as well. All right, hit us with the myths, Sheri.
All right. So, all right, there we go. Wasn't cooperating there. All right. So some of the myths we're going to dispel. Excuse me. Myth number one: if a worker is an independent contractor under one law, they are an independent contractor under all laws. So as we've discussed, the IRS, Department of Labor, and various state and local laws may have different tests to determine independent contractor status. So an independent contractor could meet the standard under the IRS control test, but may not meet the standards set out by the state's ABC test or workers' comp laws. Especially for multi-state employers, it's really important to know how the state defines independent contractor for each state in which you have workers. Myth number two: you can engage someone as an independent contractor for a trial period, then hire them as an employee. So this goes back to one of the triggers that Amanda talked about, where you would have somebody filing a 1099 and a W-2 with the IRS in the same year. So a lot of companies think it's okay to hire someone as an independent contractor for a few months as a trial period, and then if they perform well, hire them on as an employee at the end of the trial period. But if you've done this, you may not be following the law. particularly if the nature of the relationship and the work performed were the same during the trial period as they were when you hired the person as an employee. So classifying someone as an independent contractor has nothing to do with time frame or trial period. As a matter of fact, excuse me, again, filing Form 1099 and W-2 for the same worker in the same taxable year, big red flag for the IRS. Excuse me. Myth number 3, I have my own employer identification number or paperwork stating that I am performing services as a limited liability corporation or other business entity. This means I'm an independent contractor. Not so much. So having your own EIN or paperwork stating that you're performing services as an LLC, sole proprietorship, or any other type of business does not by itself make you an independent contractor. This is really common in certain industries. For example, software development. A lot of software engineers will incorporate themselves as an LLC, and they want you to pay them as an independent contractor. But what you've got to keep in mind is if your company is a software development company, they're performing the basics of the basic business of your business. So it is really you as the employer that has all the risk and liability. So regardless of how the worker wants to be paid, it is really up to you to make sure that you're complying. So under the FLSA, how you or the employer characterizes your relationship is irrelevant in determining whether you're an employee. What matters is whether the reality of the situation indicates that you're economically dependent on the employer, which would make you an employee, or in business for yourself as an independent contractor. And for federal tax purposes, how you and the employer characterize the relationship is only one factor considered in many in determining whether the employer has the right to control how you do the work. Myth number 4, I'm an independent contractor because it's an established practice in my industry to classify workers like me as independent contractors. That happened a number of years ago here in Massachusetts. It was pretty common industry practice for restaurants to have delivery people and call them independent contractors. The state really came down hard on restaurants, which is how a lot of these, Grubhub and businesses like that came about. Excuse me, because restaurants realized that if they were employing people to do that kind of work, it was an employee and they had to treat them as such. So under the FLSA, what matters again is the reality of the situation, that you're economically dependent on the employer, which makes you an employee, or in business for yourself. And then again, for federal tax purposes, what matters is whether the employer has the right to control how you do the work, which will determine whether you're an independent contractor or employee. And finally, myth number 5, I'm an independent contractor because I signed an independent contractor agreement. So signing an agreement does not make you an independent contractor. Under the FLSA, you're an employee if, as a matter of economic reality, your work indicates that you are economically dependent on an employer, and you're an independent contractor if you're in business for yourself. Any label that you or the employer give to the relationship, even in an agreement signed by you, is irrelevant. Instead, what matters is whether the reality of the situation indicates that you are economically dependent on the employer. Again, you're an employee or in business for yourself as an independent contractor. So it's really important to make sure that you're properly classifying. All right, and then Amanda's going to take us home with some tips for using independent contractors.
All right, so yeah, we wanted to provide you with some tips and tricks for if you do utilize independent contractors, how you ensure you aren't blurring the lines between a contractor and an employee. So be careful advertising for independent contractors. Don't place ads saying help wanted, and avoid using phrases such as salary, wages, or steady work when you're talking about a contractor. So instead, you want to look for independent contractors who have placed their own ads. When establishing the relationship with the contractor, you also want to avoid setting a regular pattern of daily or weekly hours. As we've talked about, a self-employed individual, presumably has the opportunity to select when and where they'll work in relation to all of their customers. You also want to allow contractors to supply their own tools, equipment, supplies, wherever possible in the performance of the services required. And this will, help demonstrate that there, is a risk of loss as well as an opportunity for profit for them. You don't want to use the contractor or their employees to perform the same jobs as your own employees, so there has to be differentiation there. Do not permit the contractor to supervise any of your employees. Do not require formal or informal company provided training for the contractor or the contractor's employees. Don't require that the contractor performs services personally. If they have someone else that they employ, that other person can step in and assist in getting the job done. Don't require that the contractor provides regular written or oral reports about, work in progress and the status. Allow contractors to hire their own assistants if necessary, and make sure that they are paying the payroll taxes normally required for such employees. Don't include contractors unless the insurance coverage, under any insurance coverage for, things like workers' compensation, health insurance, benefits, those types of things. Those are specific for employees. If possible, compensate such independent contractors on a per job basis rather than per hour or per week. And always ask for an invoice or statement before paying for any work that has been performed. If possible, make checks payable to a company rather than to an individual. Do not directly reimburse contractors for any expenses they might have, things like gasoline, meals, etc. These expenses really should stand as part of the contractor set fees. Remember that, in theory, you can't discharge a contractor from employment. So if you're dissatisfied with a contractor's performance, you want to take a look at your contract for a remedy. If there isn't a contract, sever relations with the contractor by offering no more work. And last but not least, put it in writing. So it's best to have a contract in writing with an independent contractor. And although this, as Sheri mentioned, this is not, conclusive, it can be used, on your behalf to demonstrate the validity of an independent contractor relationship amongst many other factors that we've covered today. All right.
All right, so we've at the top of the hour, so we don't actually have time for questions today. If you do have any questions that come up, you can always reach us at marketing@mp-hr.com, and we'd be happy to get back to you on this topic. And with that, we'll send it back to Amy.
Thank you, Sheri and Amanda. Great program. And just a reminder, we will be sending out a recording of the program as well as the slides later today. Thank you all for joining us. I just want to remind everybody that we have a great webinar next week, same time, same place, on employee handbooks, covering important information on how to update your employee policies for COVID, including vaccination guidelines, developing remote work policies, finding out which states have had marijuana legislation passed in 2021. A really great program. For our full webinar listing, please visit our website. You can register for all of our webinars there, as well as download any of our ebooks or other assets. Thanks again, and have a great rest of your day, everyone.